While the state regulation of water rights can have a significant impact on ag activities and land values, it's a big issue currently looming large in Kansas, where a legal case is testing the limits regulating existing rights. Well, Roger McEowen with the Washburn University School of Law now joins us for today's Rural Money segment. And Roger, as always, thanks for taking the time to chat with us today. So first of all, give us a little background on the prior appropriation system.
Well, good to be with you, Janet. Certainly, most of the U.S. that's west of the 100th meridian, which is that longitude line that connects the North and South Poles that runs through basically Cozad, Nebraska, Dodge City, Kansas. It also forms the eastern border of the Texas Panhandle with Oklahoma. Those areas west utilize typically the prior appropriation system for purposes of how the legal system allocates water. Under that system, the allocation of water is based on a recognition that water is relatively scarce, and it establishes rights to appropriate water based on when water is first put to a beneficial use. So it's known as a first-in-time, first-in-right doctrine.
So in case of the Western Kansas is presently testing the limits, give us a little update on this situation.
Yeah, this is a district court case in western Kansas, out in Gove County, Kansas, and it just came down a few days ago. And basically what this is in western Kansas you have different layers of regulation of water law in the state. It's not like it is in the eastern part of the state, but out there are groundwater management districts that overlay certain areas, particularly over the Ogallala Aquifer, and that's just another layer of regulation. Well, what they did recently, as authorized by Kansas law a few years ago, is they created a local enhanced management area designed to deal with water conservation on a more stringent basis. The state's going to take a harder look at water conservation. So they formed this district-wide, what's called a LEMA, this enhanced management area. And then they wanted to expand it. And when that happened, then you had irrigators and ranchers and voting members of the Groundwater Management District that sued to stop the implementation of that LEMA on the basis that it violated their vested water rights. You know, I have a permit that says I can appropriate water, I can shut other people off when water is scarce, and you can't mess with my vested right, was basically their argument, and the state is acting in an arbitrary and capricious manner, and it's unconstitutional. Well, the trial court said, no, that's not right. It is. And so really, there are a lot of other details to it, but really what the case comes down to is how far the state can go in regulating existing water rights. And it's going to be a battle that's going to continue to occur in western Kansas and points further west in the U.S.
All right, Roger, as always, thank you very much for your insight. Roger McEowen, he's with the Washburn University School of Law, joining us on the phone today from Topeka.